Good morning, members. Karibuni sana to our fourth webinar, in which we are going to look at the proposed bill, the Pandemic Response and Management Bill. So welcome. As we begin our program today, we are going to look at, we are going to have opening remarks from our Executive Director. She will give us some words of wisdom, updates on where we are as FKE and some of the efforts that we have made and we continue to make on behalf of members. Then we'll go straight to the bill. We are going to look at an overview of that bill, what the bill provides for, and particularly focusing on the part of employment and labor relations, and whether this bill is a blessing or whether it is a blight. And then we will look at the question and answer session where we hope to be most interactive. Members, you are requested to ask your questions. You can post your questions. You can also raise your hand and we are going to answer as many questions as we can and as many questions as time will allow. And then of course we will have our closing remarks from our Executive Director. So karibuni sana. Right now I want to invite our Executive Director, Mrs. Jacqueline Mugo, just to come and address us and open this webinar session. Thank you.
A very warm welcome to you all members to this fourth webinar that we are holding since the COVID-19 pandemic descended on us. It's a bit difficult to believe that the problem only started in mid-March, given the kind of serious ramifications and changes that we are all feeling in the world of work. If you look globally at what's happening, it is clear that there has been a profound impact on the labor, on the social and economic sphere, and that has been brought about by COVID-19. And we knew from the beginning that there would be a serious impact on the situation in employment and that the unemployment figures would go up. We're also seeing an impact on employment, and this is pretty much what the ILO had predicted. If you look globally, the reality is that businesses have been hard hit and have had to make drastic changes in their operational capacity to accommodate the fact that many people are working away from the office as we normally know it. Indeed, the projections by IMF indicate that globally we are looking at a recession, although last week there was a very encouraging headline that indicated that next year Kenya would be able to rally and go back to the growth in GDP of 6.1%. We really do hope and trust that that will be true, but a lot of it will depend on the interventions that we make as Kenyans, as government, and as business people at this time. Sadly, globally, there are also indications that there's been a very sharp increase in domestic violence, and it's happening here in Kenya as well. If you've been listening to news, there are concerns about domestic violence, and that raises many issues about our social fabric and our relationships as a people. And we do hope, since we employers look at the person holistically and we talk about work-life balance, we do hope that this situation that has been forced upon us by the COVID-19 pandemic will give all of us a chance to rethink our priorities and our relationships, even as people stay home. And this is an area where employers can play a role in giving our employees and our staff coping mechanisms and opportunities to discuss the challenges that arise, because domestic violence is a very sad reflection of the tensions, and it has an impact on people's capacity to work and to deliver on the job. We have seen major shifts in terms of the time spent at work, And globally, it is projected that about 6.7% of working hours globally will be reduced by Q2 of the pandemic. We have indicated previously that in ILO terms, about up to 25 million jobs will be lost arising from the COVID-19, but that's just a number that is the highest that is possible. Of course, a lot of it will depend on the interventions that are made. And here in Kenya, we did appeal to you as employers from the beginning to try as much as possible to keep people in jobs, at least in the first month of March. I know many employers have done that in April, but the situation will get more and more difficult as we go into May and beyond. And interventions such as the one we are discussing today are very crucial to see whether or not we're actually heading the right way. We also know that there is a very sharp distinction between the capacity of the developed economies and the developing economies to help business and the citizens cope. Africa is very vulnerable. We have previously talked about our healthcare systems. We've talked about our economies and our lack of social protection mechanisms. And this makes it a little more difficult for government to actually consider some of the proposals that we gave to government as soon as we knew that COVID-19 had arrived in Africa. We did ask for concessions to be given to business. We asked for wage subsidies. We asked for tax rebates, which was done, but partially, a whole host of issues. But because we are a developing continent, we know that we are more exposed, we are more vulnerable, and government cannot give the kind of support and interventions that we've seen in economies such as America and others in the West, where the government has pretty much taken over the burden of the payroll, so it's possible to keep people in jobs. In particular, as you look at the high levels of informality in Africa and other developing economies, and also the high level of existence of SMEs and MSMEs, we know that these are sectors that are very vulnerable and are exposed. So the underpinning theme at this time, as we continue to grapple with the coronavirus pandemic, is our commitment to saving lives, to saving jobs and protecting livelihoods, and doing that through support to enterprises so that they can be sustainable and survive through this crisis. In our view, jobs and enterprises are interdependent. Hence, there is need for balanced approaches if we are making effort as employers and as government to protect the working population, which is important. Similar initiatives need to be taken to protect business, because the people who are out of work now by virtue of COVID-19 will need a place to go back to when the economy picks up. So it's very important that these interventions address both the workers and the workplace and employers. So what we're saying is that the pandemic is unprecedented, and it calls for balanced interventions to support all players and all stakeholders, employers included. And we're happy to report to you that actually FKE has remained very actively engaged in the discussions that have been happening. And we have been pushing consistently for support to be given to employers and to businesses as a whole. As we grapple with issues such as the crafting of new laws, we think it's very important for employers' voice to be included in the design and implementation of whatever is being proposed, including the formulation of laws and any interventions that go towards protecting workers in the workplace, because by and large, it's employers who will do it. In our view, social dialogue as we know it is critically important at this time, and we have actually been pushing for this. There has been dialogue happening, but we are yet to realize one of our aspirations as FKE, and that is for us and the workers' representatives under the Ministry of Labor would agree to what we are calling a framework agreement or a memorandum of understanding that would provide the framework within which bipartite discussions can be held at enterprise level to look at the various options that are open to employers in addressing the issue of what do we do with workers at this time. That kind of framework agreement would outline the options that we have already given to you, what we are looking for is an agreement at the top level in terms of the leadership within our sector, so as to send the right message to everybody and to the country that yes, we have advised our members and employers have taken the steps of sending people on paid leave in the initial stages. When that is exhausted, we are aware that the other option is looking at discussions with the employees and with the unions on taking some pay cuts or going on unpaid leave. But of course, the issue is for how long can you keep people on unpaid leave? So last week, the bill that we're discussing today was published. The Pandemic Response and Management Bill. We have looked at it, and we hope you've looked at it because we shared it with you and it was published. And we thought it's very important for us to focus on that conversation in today's webinar so that we address the issue as to whether or not this bill actually answers the challenges and the problems that we are already experiencing due to the coronavirus pandemic. Is it possible to adhere to what the bill is saying? What really is the bill saying? Is it the silver bullet that will answer some of the gaps we are seeing, both in the provision of social protection and in law? Is it possible really to address everything from a legal perspective? If the law is silent on matters of unpaid leave, do you need a legislation to cover that? So we have prepared a summary of what this Pandemic Response and Management Bill has. And I now want to ask our Head of Legal and Labor Relations, Grace Kanyiri, to take you through it and to answer this question. What really are the main contents of the Pandemic Response and Management Bill, Grace? What does it contain and what impact would it have on employers? I give the floor to you, Grace, to take us through that. Thank you all very much.
Thank you very much. That is our Executive Director. Thank you even for giving us that background. I believe many employers are encouraged just to know that we are standing with them even during these unprecedented times. So we are very grateful for our Executive Director. She has been championing a team here that we can call a rapid response team, even to the challenges that we have and that we can see. So I want to take us now straight on to the bill, and just to look at an overview of that bill. What does it provide, and how does that bill affect labor relations? So I want to share with you a presentation that we have prepared that just gives an overview of the bill and how we can how this bill affects employees. So karibuni sana. This is what we are calling what is the proposed Pandemic Response and Management Bill 2020 and its impact on employers. This bill has been proposed by an ad hoc committee team by the Senate. And I trust that even as we go through an overview of the bill, you will have a general feel of what the bill contains. So part one of the bill basically looks at the application of the bill. This bill is supposed to apply only during the pandemic period. And it provides for a framework of coordinated approach. I'm sure members, when you looked at that bill, you found that in the content of the bill, we really didn't see the involvement of private sector. However, they have indicated that it is to provide a framework of coordinated approach, and that the bill shall supersede, override all other existing laws. And I think this is where we are quite alarmed that this bill is supposed to override other existing laws, and other existing laws have been well thought. So we really need to look at the provisions of this bill and see whether we would want them to override any other laws that are in existence. Part 2 of that bill is basically on the declaration of a pandemic, and they give the CS the power to, to inform the president that there is a pandemic situation, and then for the president to announce that. Of course, we would want to bring to members' attention on who declares a pandemic. Is it the WHO, or is it something that is declared locally? Those are some of the dynamisms that we can look at when we talk about declaring a pandemic. And in the event that the president doesn't declare it as a pandemic, then what? And then we look at part 3 and 4. Part 3 and 4 basically establish the national and county pandemic response committees, their functions, their composition, and also we'd ask members to look at that composition very carefully. You'll find also that we do not see private sector involved in the composition of those pandemic response committees. And this is disturbing because we are also part of this society, and I believe there are key stakeholders who should be involved or who should be part of that committee. Employment and labor relations sector, or rather employment sector, has really been affected by the pandemic, and we are key stakeholders, and therefore we should actually appear somewhere in these committees, even as, if at all, they're established. And then we look at part 5. It establishes a pandemic response fund, and the object, and it provides the object of the fund, means why the fund and for what purposes, and then the sources of the fund, which, if you look at the provision of the bill, is from donors, from well-wishers, the expenditure of the fund and the administration of the fund, and winding up of the fund. Again, key stakeholders need to form part of the board that administers this fund. Part 6 provides the socio-economic protective measures against, we've just put there, against lending institutions, landlords, employers, and business enterprise, because these are the main persons or institutions that have been, let me not say targeted, but have been contained in this bill. And this is where the crux of the matter is, and I would refer all of us, I believe you have a copy of the bill, to look at section 30 and what it provides in respect to employers-employees relationship. Of course, the others, some of you could be landlords, I know, or lending institutions. You could also look at those provisions under part 6. Part 7 provides for penalties for failure to comply with the provisions of the bill. We are also alarmed by the fact that this bill doesn't give us frameworks on how you arrive to these penalties. Who is the let me not say watchman, but who is which party? Is it the Ministry of Health? Who is doing the investigations? Who is doing the charging? Does this fall under the stream, the criminal stream? Or is it, how do you deal with this? So that framework is not quite clear. And if you look at some of the penalties, they're quite high. Penalties for failure to comply with the provisions of this bill, up to $1 million. And these are times of the pandemic when finances are scarce. So again, really, is it tenable in terms of even the penalties that we envisage, and also the jail term and so on and so forth. So it's also good to look at the penalties and see whether they are really something that we want, especially during a time like this when we have a pandemic. So basically that's an overview of the bill. Part 7 is important to say that the cabinet secretaries, and there's one on the Ministry of Health, there's another one on employment and labor relations, but particularly when the one for employment and labor relations, the cabinet secretary of the Ministry of Labor and Social Protection has been given powers to make regulations. And something interesting about the bill is that it provides regulations, that it can prepare regulations to expand the list of essential services, which I believe it's a good thing. It's time for us to go that direction. But we also want to look at this bill and ask ourselves, is it better to have some of these provisions in this bill, or should we just amend our labor laws, the Labor Relations Act, where it has the provision for essential services, and just to expand that list. So we are looking at and exploring whether this bill is really a blessing or whether it will create chaos or different kind of a situation. So we have set out some of the questions. We've been receiving questions from members through email, and some of the questions that we have received and some of the concerns as well are, is this bill a necessary intervention? And we want you to be very interactive. I believe you've gone through the bill. Very interactive of whether it is necessary. Should we resolve the challenges of this pandemic through legislation? What gaps in our current laws are cured by this bill? Because we all say that, yes, indeed, we have gaps, we have a lacuna in the law. Perhaps we do not have a law that addresses force majeure. These are acts that go beyond our human understanding or our human capability. So are these gaps really cured by this bill? And what provisions are currently available that complement the objectives of this bill? Does the bill provide solace or chaos? So even as we look at these questions, and even as you are interactive, we want to share with you some of the concerns, as we've said, that we have seen in the bill, and whether this bill is a necessary intervention. We note that if you look at the provisions of Section 30 of the bill, which deals with the employer-employee relation, and I just want to read it out loud to you so that you just see what it says. It provides that where a pandemic adversely affects the ability of an employer to pay salaries and wages, notwithstanding the provisions of the Employment Act, an employer shall not terminate a contract of service or dismiss an employee. So when you look at the provisions of this section, and part B, where it says an employer shall not coerce an employee to take a salary cut, we know that the impact of this COVID-19 pandemic, for example, the impact is that we are not business as usual. It's actually business unusual, where we are having a lot of businesses shut down. We talked about the tourism sector in our last webinar. We talked about the hotel industry or hospitality industry. And you'll find a lot of establishment, not just in tourism and that floriculture, and various companies have been unable to do business as usual, and many have shut down. So in those circumstances, when you have a bill that says that it supersedes other provisions of the Employment Act, for example, the Section 10 that we have talked about, that allows parties actually to dialogue and to come to a common understanding. What is the meaning of these provisions when we say that they shall override or they shall supersede those provisions in the Employment Act? And despite, they say in part, despite subsection 1, where an employer is unable to meet its obligations to pay salaries or wages, the employer shall permit an employee to take leave of absence without pay for the duration of the pandemic. I think it's important to say that leave of absence, or what we are calling unpaid leave, does not completely absolve the employer from meeting some of the obligations that are contained in an employment contract. Last time we talked about house allowance. Those are some of the statutory obligations that an employer, as long as you have an employee in employment, should meet some basic costs to keep that contract alive. So unpaid leave does not generally mean that there is no obligation by the employer. We have statutory deductions. We have social protection benefits like pension, like NSSF, NHIF. What happens during such a time? And of course, this provision of this bill is saying you cannot terminate, you shall not coerce an employee to take half pay. We also know, because of the curfew, because of some of these measures by government, you're not able to get full production in terms of working hours and all that. So what happens when people are working half day and they're not allowed to take half pay, and so on and so forth? So these are things to look at very keenly and to see, is this bill necessary, or the provisions of this bill necessary? So they may have been well-intended and very maybe noble intentions, but in terms of interfering with the free will of parties to negotiate, parties to dialogue, parties to come up with a resolution that has come out from consultation between the two parties, then is this bill really constitutional? And is it a necessary intervention? You'll also see part 3 of section 30, that the cabinet secretary responsible for matters relating to labor may, with the approval of Parliament, develop measures to cushion employers and employees during the pandemic. And my question is, if the government is not offering reliefs to employers, can it then dictate how employers are to behave when it comes to contractual engagements, contracts of service between themselves and the employees, or CBAs for that matter, between the employer and the union in respect to the workers' rights and interests? And therefore, this brings a very interesting angle on whether there is even legality in the provisions of this bill. If you look at Article 30 of the Constitution, it prohibits servitude, slavery, and servitude. And when you look at the provisions of this section 30, where it says you cannot terminate, that is basically imposing a worker on an employer, perhaps who has no capacity to afford, is unable to afford, or is unable to sustain. Then what does that mean when we look at the provisions of the Constitution under Article 30? It means that the provisions of the proposed bill do not consider some of the foundations of the labor relations, foundations that have kept the industry, the labor industry, a tripartite. We have the role that's played by the tripartite partners. It has completely done away with the aspects that my brother Moses Ombok shared with us in the last webinar, where there has to be social dialogue, there has to be communication, there has to be an exchange of that, so that parties come up with an agreed position, with a position that balances the rights and interests of both parties to contract. So that is one thing that we really have wanted to highlight to you. If you look at the provisions of Article 19, Article 20, 21, and 22 of the Constitution, it talks about fundamental rights and freedoms and their application, implementation, and enforcement. And we know that our Constitution really protects the Bill of Rights, and particularly the rights and interests of the Kenyan citizenry. So when you look at the provisions of this bill, of course, we are not focusing perhaps on the other sections, but on terms of the lending institutions, many of which are our members, and on landlords, and on also contractual engagements, which may not necessarily be contractual engagements employee-employee. I believe employers have a lot of service providers that are providing them with different kind of services, be they labor, be they the usual things that you need for your office. This bill also speaks to that, and it does not appreciate or respect the fact that the contract between two parties has what we call a sanctity. A third party cannot come and interfere with that contract unless there's an illegality about it, or there's fraud that is attached to it, or something like that. So it's important for us to look at that in light of contract law. Then should we resolve the challenges of this pandemic through legislation? Is legislation really, these throat cut provisions, which, as you can see, there are penalties, can they really be resolved through legislation? That is a question to you, members. Look at it and let us know. We are hoping to receive your questions and your perspective on that. Then what gaps in our current laws are being cured by the provisions of this bill? Is this bill really addressing issues of unpaid leave? What is the framework that we would talk about unpaid leave, for example, because they have mentioned something with the leave of absence, does it really provide that framework? Does it really provide an exit? Does it really cure issues of force majeure? Does it really cure that? Does it really cure things on frustration, the doctrine of frustration of contract, which you talked about last time? So some of these gaps, are they cured by the bill? And then what provisions are currently available that complement the objectives of this bill? And does the bill provide solace or chaos? So that question is to you, members. I am here with my brother, Mr. George Masese. We are going to answer some of the questions that you've been sending to us, and also looking at the questions you are asking now. And we want to open up this session for question and answer. We want to look at it from the perspective of the social impact this bill has, the legal impact it has on contracts. We are looking at it from the social angle, not social, but really labor relations angle, in terms of your relationship with the employees. What does it mean for us? So I want now to open it to us members and answer some of the questions that you have already asked. We also have my colleague Grace Kaome, who is going to take us through the question and answer session so that we can be well organized in answering all the questions that you have sent to us. So over to you, Grace Kaome. Kindly let us hear the questions that members have been asking.
Thank you very much, Grace. We appreciate the overview that you have provided. We have received quite a number of questions from members, and I'll start off with one that came from Jack Shihundu of White Rose. And Jack is concerned about the bill, and he says that the employer shall not terminate a contract during pandemics. So he's wondering what should be done with the casual contracts that we have. I'd like to request my colleague George to address the question of casuals and what this means in as far as that kind of a contract is concerned.
Thank you, Jack Shundu, for your question. I think it's going to help many of us understand how we are going to manage the crisis during this period. But first and foremost, as per the question, the way you framed it, it's like you framed it under the premise of the Pandemic Response and Management Bill, and therefore assuming that now we are working under the Pandemic Response and Management Bill. What it means is that this bill has not been passed into a law. It's just a bill for discussion. It is still before the Senate. It has not been passed into a law. So therefore, any suggestion in that bill is not binding as we speak. So therefore, we should not dwell so much on what limitations that bill is trying to impose on employers. But the most important thing is, let's really work on the Employment Act, what it provides, and also look at our policies, what they provide. And if our policies are able to provide for situations which are not foreseen, for example, this pandemic, then we are lucky. For those of us who had such kind of policy, but if we didn't, then we better work under the Employment Act. And you see, the Employment Act basically has defined casual contracts, and for many, it has been a long journey for the courts to realize that really they have to appreciate that casual contracts still exist, and therefore during this period we should treat these casual contracts in the normal way that we have been treating them before. But of course, with much exceptions as of now, because at this time we can either decide to use those casuals to carry out our business, or we can decide to do away with casuals. Then we now offload all the work to the permanent or those contract employees. So basically, in short, is that this bill is not has not started limiting any rights of an employer to manage this business, and therefore we work under the Employment Act. I don't know whether I should go to the second question that has been asked, whether scaling down operations and sending off staff on unpaid leave, and after doing so, the revenues generated cannot be able to sustain the remaining staff. Can an employer opt for salary cuts, which is forbidden again under the bill? Now, again, as I've said, the bill has not become a law as we speak. And therefore, what is happening at the moment is that really we are applying what we call Section 10(5) of the Employment Act, whereby we are renegotiating the terms of the contracts. All right. So therefore, what an employer needs to do right now is to apply or put in place those several tools available at his disposal. When we talk of a salary cut is one of the tools that we are using. We are talking of unpaid leave is one of the tools we are using. But of course, you should also have some policy guidelines on that during this period, which can guide you. Most of those who have unions, I believe unions have been able to give you some comments or some contributions on how you should manage your business during this period. And when you look at these tools that you have, it doesn't mean that when you apply one tool, it means you cannot apply the other tool. You can have a mix of tools together. And I think this is a discussion we've had with most members, whether we can have a salary cut, at the same time we can have this unpaid leave. Yes, you can do that, and you can do both. You can do rotational unpaid leave. At the same time, you have salary cuts. What we are trying to do, as the executive director said, is that we are looking at this employee as a complete person. So when he's on unpaid leave, he's not getting anything. So therefore, what we need to do is that we must be able to rotate. When this group is on unpaid leave, we should also be able to rotate and have the other month, those guys who are out and on paid leave, they can come in and work, but still earning these salary cuts. I believe that answers the question.
Thank you very much, George. So I will now call onto my colleague, Grace, to address some questions that have come through. And there's a member by the name David Nyanja. David is asking, is looking at this bill and is considering the post-pandemic period. He's saying he's not able to see any provisions in this bill that speak to what employers should do after the pandemic. And the specific question is, if the employer is not able to pay salaries after this period, yet the bill is restricting termination or redundancies during this period, what cushion is there for employers past the pandemic?
Thank you very much, Grace. Indeed, when you look at the bill, it does not provide for any post-COVID measures. What will happen, and is the fund going to be utilized to revive businesses? So it's a very limited bill. When we look at the bill, it is very limited in its application. It is also very prescriptive when it comes to those measures, the socio-economic measures, as I said. So it's unfortunate that it doesn't cover for that. And for us as the Federation of Kenya Employers, that is a very critical stage for the nation and for employers to be revived, to awake, and to be able to pick up from where business left, or where we were left in terms of because of the pandemic. So it is a very valid question. Unfortunately, the bill doesn't cover for that. But maybe for your comfort and just for your knowledge, as FKE, we have been having several meetings with the CS of Labor and Social Protection, and we have been pushing even to government for the government to be able to cushion employers, to provide for funds, perhaps to revive SMEs, businesses in form of grants. We have seen tax subsidies, and those are some of the proposals we had given to government, and we are so glad that the government was able to meet us halfway and meet some of these tax subsidies. We are still pushing, because for our economy to be revived, we definitely will need some post-COVID some post-COVID measures. And we're encouraging members, please send us your proposals. Please send us your ideas on how post-COVID government can intervene, social partners can intervene, so that we are revived more sooner than later. And you can send that through our contacts. We'll be sharing with you our contacts, our email contacts, our phone contacts, so that we can prepare a collated document, a document collating all your views on how we can mitigate post-COVID, taking care of the mental issues that may arise due to stress and all that. I believe you all had our executive director when she talked about even domestic violence and some of these kind of social problems that are arising out of it. Thank you, Grace.
Thanks, Grace. And so I'd like to tie that to what a member by the name of Philippa has asked about whether employers have a say in this bill. Yes, employers have a say, and Grace has just confirmed that you can send in your responses and your contributions to this bill, and FKE will provide one compiled response that goes to the relevant parties. So Philippa, please consider that. There is another question from that same person. Before then, we request you to start raising your hands. We will allow you to ask your questions live shortly, but we'd like to address a question, and this I'd like to give to Masese, around the bill says that the employer may permit an employee to go on unpaid leave. So it says that then that responsibility has been passed on to the employee to request. So it says if the bill has already put the employer in a situation where they can only accept or a request that has been made by the employee, then what incentive would these employees have to apply for such unpaid leave? And what options do employers have in that kind of a proposal? Maybe Masese, you can take that.
Yes, to answer that one again, I think the way I'd answered the first one is that this bill has not yet been passed into a law. And if you look at the Employment Act, the issue of leave or sending or not sending somebody on leave is actually a preserve or a right of an employer on how he's going to manage his business. So therefore, it's not a question of an employee requesting. And if any law comes into place that says that an employee is going to request for leave, then it takes away the right of an employer to manage his business. And because the employer is the one who keeps records, is the one who can send a person on leave, is the one who allocates duties, is the one who knows when an employee is needed at work or not. So therefore, for me, so long as this bill has not been passed, it has not taken away the powers and the rights as provided for under the Employment Act.
Thank you, George. So one last one, then we take your questions live. And this question I'd like to ask Grace to respond. It's a question that a member is asking about what to do with an employee who is infected by COVID at the workplace. Will it be treated as an occupational disease? What is the employer required to do in an event that an employee is infected?
Thank you very much, Grace, for that question. Indeed, where you have an employee who is infected, and we have seen this even in some of the articles we've seen in the papers, the immediate action of quarantine is very important. Number one, that particular employee should be quarantined. Number two, you must get in touch with the nearest medical center so that they can be able to handle this infected employee. They can be able to give immediate medical attention to that employee. And in the meantime, because he has been perhaps associating with other employees, it is very important because of the seriousness of the infection rate of that the disease, the corona disease. It's very important for you to also isolate the other employees, let them be quarantined either at self-quarantine or even quarantine the workplace so that you do not have people coming in, people going out and infecting others. And this is very important. That rapid response is what will save perhaps the lives of many Kenyans. I believe this employee has a family, this employee has friends and perhaps relatives and people maybe he lives with, neighbors. So you can see how quickly it can spread and even affect very many people. So it's important to immediately quarantine this person and immediately call the Ministry of Health. We shared earlier, and we can continue giving updates on some of the contacts we've received from the Ministry of Health, where you can call them, you can immediately report. And worst case scenario, if you have no contacts, no nothing, just call 999 so that you can, or 911, so that you can get an immediate response for that particular employee to get medical help. And once they get medical help, I believe it's important for that quarantine so that they do not infect others. I believe the government has machinery to even look at the people they have been in contact with. And those are some of the actions we've seen with government, asking and investigating the people they've been in contact with, so that also those other people are protected and they are given medical services if need be. And they are also quarantined so that the disease, we stop the spread of the disease. Thank you so much, Grace.
Thank you, Grace. At this point, we'll give a chance to Nancy, who has a hand up. So Nancy, kindly, you may ask your question live. Nancy, please.
Sorry. Yes, thank you so much, team, for your very, very insightful discussions. I have a question. Considering that this bill is a proposed bill that is for the COVID, for the period of this pandemic, if you take action as an employer using the Current Employment Act, won't it be rendered, if the bill is ascended to, wouldn't it be rendered and maybe bring up litigation issues, because you are taking an action during a pandemic period, and this bill, I don't know when it will be effective, but I'm considering that it will be within the pandemic period. So does it suspend the employers from doing what they need to do in the fear of that this bill, if ascended to, or if it enacted into law, will render all the other actions employer has taken invalid?
Thank you. Thank you for your question. Indeed, there is a concern that employers have already taken some action. For example, in the hospitality industry, where we have the hotels and caterers, the association, the Kenya Hotels and Caterers Association, did agree with the union, KUDEIHA, and agreed on measures which they'll take during this pandemic. And they have already implemented some of these measures. So you can see how when a pandemic bill comes proposing to supersede all other laws, then it interferes with that very important role of social partners to dialogue and to find solutions. Remember also that the pandemic does not affect all employers alike. There are some employers who have been adversely affected. There are others who are making a kill perhaps during the pandemic. We also have multinational companies that are not dependent. Their salaries are not dependent on maybe people working. They are not as service, they are not in that service industry where the service brings direct income. So there are different kind of employers. The impact of the COVID-19 has affected employers differently. And that's why we are saying this bill, if it comes to, it's very limited. It's also very prescriptive. You can't tell somebody you cannot terminate, you cannot give a pay cut, you cannot do this, you cannot do that. And yet perhaps you have already come to an agreement with the employee on how to manage that situation. So for us, our position is that we are encouraging employers to give their comments about this bill. Because you see, this bill, if it stands to law, will directly impact you. For us, we are looking at it and saying that, number one, it has unconstitutional provisions, because the Constitution is the one which gives two parties freedom to contract. So we are telling parties, or rather we are telling employers to give their views. Is this what you want? Is it something you want that is so prescriptive? You have also said correctly that it's supposed to be during the pandemic period. How long is the pandemic period? Is it 1 year? Is it 6 months? Is it 2 months? Is it 3 days? There is no telling on how long this pandemic period is. And there is no telling who decides when. Of course, the act says that the president will announce when the pandemic is over. But as we said, the impact of this COVID-19 will go beyond the pandemic stage. We've seen second waves in Korea, in China, where there's a second wave of infection. Then what happens? So I think the answer for now, since it's just a bill and it has not yet come to law, we are going to collate the views of our members. We are going to present a memorandum to Parliament so that they can look at this kind of issues and perhaps come up with either a better bill or amend the sections of law in the employment laws that, that would need beefing up. So I think that is what I can say to that question.
Thank you, Grace. At this point, we will give a chance to Nina to ask her question live.
Hi, Grace Kanyiri. I would like to direct this question to you. I hope you can hear me.
Yes, we can hear you, Nina. Please proceed.
Oh, all right. So it is going back to a question that was answered on occupational safety and health, which you answered concerning the reporting to the required authorities, health authorities. However, I think the person also, the question would also take a different angle, whereby, you know, as per the DOSH requirement, the DOSH law, we are supposed to categorize diseases, whether they have occurred at the workplace or not, and then report them like formally by filling the DOSH form one. So in that regard, when an employee is infected, it is not necessarily that they got that infection at work. They might have gotten it somewhere else. Then come Monday morning, they came to work, and then at the workplace on Wednesday, we discover that this person is now ill. So, but the source of illness was not the workplace. So in that regard, are we going to report it by filling the DOSH form 1 and saying that it is an occupational disease? Or are we just going to report to the Ministry of Health and forget about it? Thank you.
Thank you, Nina. COVID-19 has not been defined as an occupational disease. And if you look at the definition of an occupational disease in as described by OSHA, I don't think it quite fits that definition. And as you rightly say, the employee may not have contracted the infection from the place of work. However, rapid response, immediate rapid response is so important because we know how infectious this disease is. We know that it spreads even before symptoms show. We know that it spreads when somebody either sneezes, coughs, and it's a respiratory thing. And we know that there are those who are more vulnerable, there are those who may just be carriers and nobody even really quite knows. So it is so important that that immediate, rapid response to the relevant authorities, and that means the medical center near you, it means the government if you can't get a medical center, is so vital, because right now, if you look at the formalities, by the time you fill the forms, by the time infection is happening, okay, I'm imagining, I'm taking it to the next level, but infection could be happening rapidly as he communicates with other employees and so on. So isolate the employee, let them be quarantined, inform the relevant authorities. And I believe in that informing them, then they will be able to take quick action. Remember, right now, it's not an epidemic in the extent that it has, it's not moving as fast because we are all taking personal responsibility and precautions, and we are taking the precautionary measures very seriously. But if we allow these kind of people to go through procedures, it may not work for them. So for right now, the OSHA Act may not apply in the sense of the formality that usually it works. This is not an occupational disease for now. This is a pandemic that the whole world is struggling with. So Nina, I hope you will, if you've seen of such or something, rapid, quick, immediate action is what we are asking employers to take. And that isolation is so important so that nobody else is put to risk of infection. Thank you, Nina.
Thank you, Grace. We'll allow Apollo to ask his question live. Apollo,
Thank
please.
you, Grace. I'm addressing this question to Grace in terms of what the ED talked about the framework agreement with our social partners. Because I remember the CS gave guidelines the other day in terms of how to mitigate against the impacts of the virus into employment situations.
Yes.
And as a result of that, I've seen in today's paper, when an employer decided to amend or change the terms and give a salary cut, one of the unions moved to court. And there's a matter that is proceeding in that respect. So as we discuss the bill, I think what do we need to do as employers to safeguard ourselves against these kind of situations, and see that we have that framework with our top level social partners, that whatever we agree and we put in on pen on paper, it safeguards the interests of the employers. Thank you.
Mr. Apollo Kieri, thank you for your question. Let me say this, that unfortunately, we cannot stop individuals from rushing to court or from suing because it's their constitutional right, it's their right to go to court. But on whether there is any success to such an action, to such a litigious action, is something else. I don't think, and I truly believe that the courts, which have also taken measures to reduce the spread and infection of COVID, and also understand the predicament of parties, will respect, even from what we call precedent law, will respect the agreement of two parties on what they have agreed to mitigate the effects of COVID on the employees. And believe you me, when we have that social dialogue and when we have partners coming together to discuss, to consult, and to find a common solution or an agreed position, that agreement, there is a sanctity to that agreement that an outsider, a third party, cannot come and challenge, even the courts. And we do have authorities from the courts that say the purpose of the court is to interpret those terms, but it cannot come, even though the court may feel that those terms may not be fair. The court cannot interfere, and it cannot change, it cannot vary terms that have been entered by two agreeing adult consenting parties, unless there is fraud, unless there's an illegality about that agreement. So in this case where we are talking about somebody rushing to court, nobody can stop that. But on whether they have success in that action, understanding and knowing what the pandemic has done and how it has ravaged a lot of businesses, I don't think there's much chance for success in that case. But let me say this to employers: let us come together. Let us talk with our social partners, for those who have the union presence in your workplaces. Let us agree on a way forward on how we can mitigate these effects. For those who don't have union presence, please have these conversations, whether they are virtual or by way of email calls or whatever. Have these conversations with employees so that you agree on a position that balances the rights and interests of both parties. And that is why we are saying, send your comments. This bill is just at the proposal stage. It has not become law. Look at this bill, see how we can put our input so that the bill either helps us or we are able also to communicate to Parliament that the bill is not a good intervention for now, and perhaps it does not create solutions, and perhaps it also creates more chaos than solutions. We really need to look at the bill, see what is good about it, what can help us, what perhaps may not help us, and then we present this in form of memoranda to Parliament so that they can also hear our perspective. Thank you so much, Apollo, for that. I hope that has answered the question.
Thank you, Grace. So we'll take just one more question. We have received quite a number of questions. I'd like to assure our members that we will take all the questions, consolidate them, and provide responses, written responses through the email addresses that have been provided. But I would just like to give one more chance to Lillian to ask the last question to allow us to move to the next level. Lillian? Okay, we seem to have lost her. Lillian, are you able to hear us? Okay, thank you. So we'll give a chance to Carol. Carol Githinji, you can put your hand up. Kindly ask your question.
Okay, my name is Caroline Githinji, Toyota Kenya. So I just want to ask a question. In terms of government directive, it has become very clear in the public sector that people with pre-existing conditions, pregnant women, are allowed to work from home. As FKE, what guidance are you giving the private sector?
Thank you, Carol. Judge, please take the question.
Okay, fine. As a federation, still we are still following what the government directives are, and if you've been reading the circulars issued by the Ministry of Health, I think that is what we are currently using. And of course, the public service, the president has also advised that people who are above a certain age should not be going to work as such. Now, what happens in the circumstances is that each and every company must come up with its own policies to guide itself in terms of what the bigger picture is talking about. Okay, so therefore, am I edible? Yeah, so therefore, what happens is, as the government is still advising from that overall perspective, then down there, we must be able to come up with our own policies, of course, in line with the guidelines given by the government. And it depends from one case to another. You can find an organization where everybody is above 50 years of age. So does it mean that if you cannot be able to work from home, so that everybody now must work from home? One, you must go to your workplace, but ensure that you comply with social distancing. Now, there are instances where you find very young generation, but they are able to work from home, all of them. So do you need them again at workplace and to ensure those kind of issues? So, you don't need. So I think it's from one company to another. It doesn't apply across the board that this is the solution that is going to work as what the government has said. And we have seen even the government itself, even if you look at the Ministry of Health, we've seen people above a certain age still working. It's because their skills are needed at that time. So I think for me is that what we are advising our members is that we can assist you in terms of developing those policies quickly as possible on need basis. So if you have a need for you to develop such a kind of a policy, kindly get in touch with us. We can assist you develop a policy to guide you during this pandemic period in line with the guidelines given by the government.
Thank you, George. So we have received quite a number of questions. As I've confirmed, we will provide the written responses in view of time. So kindly bear with us if you have not been able to address your question live. We will send in the responses. At this point, I've seen quite a number of questions that touch on payroll, and especially that members are completing their payrolls at this time. And it's in regard to the payee recommendations that were given by the president, and people are asking whether or not they should implement those when doing the payroll for this month, or whether they should wait for a gazette, or whether it is up. So maybe Grace can just comment on that quickly before we close the session.
Yes, thank you, Grace. With regard to pay as you earn and on how to work it out, at this time, we know for sure that there were some tax laws that were presented to Parliament. That included the VAT issue, and it also included the pay as you earn issue that the president had announced on the reliefs there. The VAT aspect was already passed by Parliament last week, Tuesday. I believe this Tuesday, the pay as you earn aspect was also brought before Parliament. We are waiting for the passing of that law so that then you work with something that has officially been gazetted. And once that law passes, it will be gazetted, and I believe employers can use then the law to apply. But for now, we are advising employers, many of us who do our payroll early, please do not implement and also do not release the pay as you earn, the 30%, for example. Hold on to the 5%. because you'll do your returns by the 9th of the following month, hold on to it so that whatever is released to government, you know it may never come back. You only release the 25 for now as we wait, or you wait until the 9th when you have to make your returns as we wait for the passing of that law. That law may also be retrospective, means it may, effective date of that law may be the 1st of April. So we are saying hold on, pay the employee as usually pay them, because also when you release to them, it might be a challenge getting it back. And then that indecisive amount, the 5%, we will make a decision once the law is passed. And we are hoping by the 9th we'll have that law in place. So thank you, Grace.
Thank you very much, Grace. We have closed our question and answer session. We will be getting back to all the people that asked their questions, and we are still asking that you submit your written memorandums and responses to this bill, which we shall collate and provide as one document on behalf of FKE. At this point, I'd like to hand over the session to our Executive Director, who will provide our closing remarks and give us a way forward. Thank you.
Thank you very much, Grace and George, for your active involvement, and also to members for that engagement. Members, before I share with you what I think are my takeaways from the conversation we've just had, let me share with you what we've been doing since the webinar we did last week on your behalf. The bill we've been discussing, we have looked at it as FKE. We've actually engaged formally the Committee of Parliament that's dealing with it, their Senate committee that's dealing with it, and today we'll be finalizing our memorandum to submit to them containing our views. So your conversation with us this morning and your inputs and your questions have really been helpful, and they will inform part of our proposed interventions and the issues we may have with the bill itself. So that engagement is something we'll continue doing, because this is a very dynamic situation, and you can imagine the kind of initiatives and ideas our legislators and other Kenyans may have, all aimed at helping the situation, but some of it may actually complicate it further, as it obviously seems from this bill. So that engagement has happened at the Senate level. We've also remained fairly active with the Ministry of Labor through our rapid response team to discuss some of the interventions we asked for initially, which the government has not been able to respond to yet. But we believe the support from government will be needed. It was needed when the pandemic started, it is needed now, and it will be needed in the medium term and long term to help the recovery of the economy and also our enterprises. As we've shared with you, we plan to be holding these seminars on a weekly basis. And next week, I'm glad to inform you, the one we'll be holding will actually be focusing on occupational health and safety, because next week on the 29th is also the World Health and Safety Day. So some of the issues we are discussing about OSH and how to treat COVID-19 infections by your staff, we can delve deeper in, and we hope to have someone from the directorate to discuss with us from the government's perspective what they think should be happening. Of course, the Ministry of Health has issued guidelines, which, as Grace Kanyiri has said, you should follow, and we think they're well placed to deal with that issue. The other initiative we are currently doing is a survey, which we are conducting with the support of the International Labour Organization. We hope you've received this survey instrument. If you have not, because we have your contact, having participated in today's webinar, we'll be sending it to you. It's very important that you respond, because it will show the extent and the impact that COVID-19 has had and is having on the workplace, and it will inform some of the proposals and the interventions we'll be asking for as employers to our partners such as the ILO and of course to government. So please, it's important for you to respond so that you can help us to collect the data on this survey, showing specifically the impact of COVID-19 on the workplace. As we go into next week, we also want to say that we will continue pushing for the framework agreement that Apollo was asking about, because we have sensed a bit of reluctance on the part of the union to sign it. But whether or not we do sign with the union a high-level agreement or a framework agreement or a memorandum of understanding, it does not take away your right as the employer to have discussions with your staff where you don't have a union, or with the union directly on bipartite basis where there is one, so that you can agree on what interventions work for you to address staff issues regarding COVID-19 and the fact that many of them are working from home. That has been our position from the beginning. It continues to be that the right of the employers to run the enterprise, to manage the enterprise, have not been taken away. So the other thing I want to appeal to you about is really getting involved, getting actively involved to support the initiatives that you see happening around you. You have opportunity to donate in cash or in kind. You can donate to the fund, the national fund that the president formed. A number of members have asked us if they can donate through the federation. We're willing to do this. So far, we don't have a big enough number, but we are quite willing to open an account dedicated to your contributions, which we will then forward to the government to help manage the situation. Of course, if you're able to directly give water, give sanitizers, give gloves, and any other equipment that would help Kenyans cope, feel free to do that, because we know that many employers are already doing it. If you have any challenge, any further issues, please feel free to contact us directly. Now to the conversation this morning and what I'm calling my takeaways. I think I want to reiterate what George Masese said, that this bill is not yet in force. It's a bill. It's a proposal by the Senate committee to help manage the pandemic, which we think has a lot of issues. In my view, it raises more issues than answers. It is not a blessing. We're discussing whether it's a blessing or a blight. I think Grace asked whether it's chaos or giving solace. I don't find much solace in this bill, except the provisions, of course, that propose that there be PPPs, private-public partnerships, which is already there. And also there's a reference to the Minister of Labor coming up with initiatives to push on employers, which is put in a very lax way. It's not forceful. It may happen, it may not happen. But on the whole, we are still asking, what exactly is this bill seeking to fix? Because county governments, of course, can form committees to address COVID-19. The national government has structures in place. The Ministry of Health is, in our view, doing an excellent job under very difficult circumstances and resistance from Kenyans in protecting themselves, to keep us informed, to test Kenyans. There is a challenge about the isolation and the quarantine, but I think that is being discussed by private sector and government. Those challenges are being addressed, and please keep us informed if you know of any specific ones. But on the whole, the Ministry of Health is capable of doing that job. If you look at the workplace, we have the Ministry of Labor, we have the structures for social dialogue, and we've been dialoguing with the ministry, as we've shared with you from the beginning. So you can't just pick one aspect of labor relations, put it in law, and in a way injunct employers from dealing with their employees. I don't see how practical that will be. And in fact, if the good spirit behind the pandemic response and management bill is to protect employees, which is noble, it will end up hurting them, because if you stop the employee from having conversations with the employer, how then do you ensure that enterprise will be existing and viable 4 months down the road for that employee to go back to? And how do you tell an enterprise which is closed, like most hotels are closed, we've talked about it, Kenya Airways is closed, many companies have scaled down their operations to 25% or less. How do you tell them to keep the entire workforce in employment? And even if you say it's on unpaid leave, as Grace Kanyuri said, unpaid leave, there are still some running costs that the employer incurs. So we will be sending your views to Parliament, and I was really asking us to rethink, is the COVID-19 situation calling for yet more laws, or do we really just need to discuss as a country interventions that work for us? So you can have free and open discussions with the union where you have one, or with the employees where there is none. You're perfectly free to have variation of contracts. This bill talks about employers not coercing their staff. I think that is an unfortunate terminology, because employers, really good employers, and our members are good employers, do not coerce their employees. This is a time for conversation. And to be honest, the unions are very alive to the challenges the economy is going through. They have, from what they say, no objection to that kind of conversation, and already agreements are being signed. So please do not be scared about varying the terms of the contract, of course, with the support of the employees. But ultimately, if you cannot pay, then you have, as an employer, to take certain actions, which we have already outlined, but do feel free to talk to us if you need more interventions. And those interventions can be a mix, as George said. You can go for flexibility as much as possible. You can ensure people exhaust their paid leave first. You can send people on unpaid leave. And actually, when we started this conversation, we were even thinking about people taking leave in advance, which is a new idea. That is also possible if you can agree with your employees to take part of their 2021 leave now, so as to avoid people going on unpaid leave. Of course, it has risks, because you're assuming this person will still be with you in 2021. So please take a rational assessment of what you can do, but we remain available. In terms of policy reviews and policy intervention, which we've also discussed, we have been considering the issue of force majeure clauses being included in employment contracts. This is a first for everybody, I think. Is it time that we included such a clause in employment contracts, where external forces make it impossible for both the employer and the employee to fulfill the terms of the employment contract? It cannot be addressed as a redundancy, because the employer is not in control. Redundancy is a situation where the employer takes the initiative to terminate the contract, not because the employee is at fault, but because his needs have changed and he's taking that action. And it is a very expensive exercise. So obviously that would impose additional costs on employers at this point, and I don't think that's the way to go. So force majeure clauses in contracts of employment are discussion for our future engagements. The final thing I want to say is that in terms of insurance and COVID-19, we have been pushing for a conversation with the insurance companies who are our members, and we certainly do not want to set them up, but we need to think as a country how we can achieve this. When HIV/AIDS first came up many years ago, there was fear about it, and it wasn't covered by insurance. It took a long time for insurance companies to cover it. I think now it's covered. This can be covered, but of course there'd have to be some limits set so as to protect the insurance firms from risks which they cannot manage. That is a conversation which behind the scenes we are very keen to follow. So finally, let me invite you to our webinar for next week, and to ask you to prepare your questions on health and safety. Next week is a fairly eventful week, because I think it will also see Labor Day. We're still in conversation as to how that can be handled, but we have given inputs to the ministry, which would go into the presentation by the president, where we want employers' issues addressed and included. If that doesn't happen, FKE will still issue a statement on your behalf. We will, of course, be largely focusing on the current challenge of COVID-19, commend you employers for the role you've played in toning things down, because every day we are asked how many people have been laid off work, and that we have said should be as a last resort. This discussion on health and safety will be on Monday, I believe, Monday morning, but we'll give you the exact time. So members, once again, thank you very much for your engagement with us, and we look forward to having the next discussion with you, and we wish you a good week. Goodbye.
Please get in touch with us using those contacts.